Good evening. I'm Melvin Raymond, attorney and counselor at law. Welcome to Raymond Law Live. What if a loved one becomes incapacitated and not able to perform for himself or herself the daily activities of living, such as grocery shopping, preparing meals, other things, taking care of their personal hygiene, such as bathing and showering, going to the toilet. And then there are personal financial matters, such as paying household bills, the mortgage, the rent, utilities, insurance, etc. Now, to take care of those financial matters, you will need to, of course, be able to handle the personal finances of the incapacitated individual or your loved one. So, what do you do if your loved one becomes incapacitated? Well, if that person, the incapacitated individual, has given you or granted you or someone else a power of attorney, then you should be covered to be able to assist your loved one in taking care of themselves and their personal financial matters. We have covered power attorneys in prior broadcasts. So if you don't have a power of attorney, it's always a good idea, if for whatever reason, to get one. But if for whatever reason your loved one who has become incapacitated has not granted you or another relative or someone else a power of attorney, then what do you do? It may be advisable to seek to be appointed as a guardian or conservator of your incapacitated loved one. Now, what is a guardianship? Now, we're talking about court-appointed guardians and conservators for individuals who have become incapacitated. It would be necessary to seek to be appointed as a guardian or conservative, to file a petition to be appointed as guardian or conservator in the probate court in the county where the incapacitated loved one resides. So you need an attorney to do that, and there's a number of steps and procedures you would follow. If you have questions about or comments about today's topic, that is guardianships and conservatorships, then go to our Facebook page. That's facebook.com/Raymond Law Live, or you can go to our website, that is M. Raymond Attorney at sbcglobal.net. We'll be glad to take your questions and comments during the course of the broadcast, and we will cover as many of those as we can. And one other thing before we continue with our topic, if you have some topic that you wish for us to cover in a future broadcast, then contact us on our Facebook page, or you can email us again at mraymondattorney at sbcglobal.net with your questions or comments, as well as your topic that you would like us to cover in a future broadcast. So as always, I invite you all to do that. Now, back to our topic for today's broadcast. What is a guardianship? And again, we are talking about a court-appointed guardian or conservator. So let's deal with guardian first. A guardian is when an individual is appointed by the probate court as guardian of the person, and they are authorized to make decisions about the incapacitated individual's personal care and welfare, including living arrangements. That is, whether or not they're going to be able to live at home, or maybe they need an assisted living facility, or if they have a medical condition, if they live at home or they are in a facility for assisted living, then that's referred to as custodial care, And if the incapacitated individual has the financial resources through insurance and income, then, and this is most desirable, that they remain at home if at all possible, or if they need a little bit of assistance, perhaps they can go to an assisted living facility. Now, with in an assisted living facility, they do it. The expectation is that that person can take care of themselves as far as feeding themselves, taking care of their personal hygiene, and so forth. They may need some assistance, but not any significant amount of assistance. So again, the guardian handles personal care situations, including living arrangements. Now, if the incapacitated individual needs medical care, then there are facilities, nursing homes, and so forth, where that individual may need to be placed to take care of medical needs. So if they have they're incapacitated either physically or mentally, and they have a medical condition such as maybe it's been a stroke or some kind of dementia, Alzheimer's, or some other medical condition such that they are physically or mentally incapacitated and they need medical care, then you should consider perhaps some kind of facility such as a nursing home or a rehabilitation center and so forth. You would have the authority as a court-appointed guardian of the person to make those decisions regarding personal care, including living arrangements. So that is, in a nutshell, a guardianship. What is a conservatorship? When an individual is appointed as the conservator of the incapacitated individual's estate, then they have the authority to make decisions and handle the incapacitated individual's personal financial matters as necessary for the support and maintenance and welfare of the incapacitated individual. Now again, the key here is that the conservator of the estate, so we have the guardianship goes to over the person, but conservatorship has to do with the person's estate, including the person's finances, financial assets, and other assets, handling those. So that's the difference between conservatorship of an estate and guardianship. Now the key here with conservatorships is that the conservator handles the finances as necessary for the welfare, maintenance, and support of the incapacitated person. And there are protections built into the guardianship and the conservatorship process, which we'll discuss in a moment, to help protect the incapacitated individual. So that is basically what a conservatorship is. What are the requirements of a conservatorship? And again, contact us on Facebook with your questions or comments about this topic. And I think that this is something where the need may arise in the absence of a power of attorney to a loved one, and not necessarily a loved one who is disabled or incapacitated because of a physical or mental condition, but sometimes younger people become incapacitated mentally or physically due to, let's say, an accident where they may be disabled physically and so forth. So it doesn't just happen to older individuals. It can happen to younger individuals as well. So keep that in mind. The decision about whether or not to seek a guardianship is one that deserves careful consideration. You should consider it, as I mentioned before, if you do not have a power of attorney for the person that becomes incapacitated or disabled. And also you need to consider the level of their incapacitation, because you do have to, when you file your petition to be appointed as guardian or conservator, you do have to state the reasons for uh, why the incapacitated person needs a guardian or a conservator. Now, what are the requirements to be eligible to become a guardian? Let's do a guardian and or conservator. If you are not the incapacitated person's spouse, parent, or child 18 years old or older, or a sibling 18 years or older, then the probate court requires a background screening. And what is a background screening? That you must submit to the probate division in connection with their petition to be appointed as a guardian or conservator. Well, the background screening in the state of Missouri is something that's required by statute, and the probate division will not appoint you if you do not submit to a background screening. And again, it's only if you are not related to the individual as a parent, spouse, or an 18-year-old child or a sibling of the incapacitated person. Now, the background screening is done in the state of Missouri, several state agencies, and it must include, you must submit information as to the disqualification list from the mental health department, the social services department, and the health and senior services department. And you also have to submit information from the abuse and neglect registries for adults and children. The court will not find someone suitable to be a guardian or conservator who has against whom for instance, a neglect or abuse petition involving an elder and adult person, if that person has been found to be guilty of adult or child abuse, you're not qualified to be a guardian or a conservator for a incapacitated individual. Also, you need a criminal record check, and you need a screening from the sexual offender registry. So those are quite a few requirements to be considered or to be eligible to be appointed as a guardian or conservator. And that's why it's really important to consider very carefully if you can qualify to become a guardian or conservator, and because of all the screenings that are necessary. And in addition to those requirements, if you are seeking to be appointed as a conservator of the estate of an incapacitated or disabled person, then you must submit a credit history investigation to the probate court, and you must be bondable. You have to submit a probate bond to cover in an amount sufficient to cover the financial assets of the incapacitated person whom you will be handling. It's kind of like the bond that if your plumber has to make sure that if he does plumbing repair at your home, then and something goes wrong, then you have a remedy. You can go to the insurance company who bonds the plumber or electrician for any mishaps or anything that goes wrong. You're covered. The insurance company will handle any in the case of they'll handle any problems that result in economic damages to you. So it's the same idea with a conservator having to post a probate bond. So those are the requirements, the basic requirements to become a guardian or a conservator. And again, you have to file a petition. And part of the petition, and this again is one of the other qualifications for guardian or conservator in order to be appointed is you have to state in the petition the reasons for the appointment, why the person needs a guardian or conservator. Now, the idea there, basically, you have to show that the incapacitated person has a physical or mental condition such that they're not able to provide for themselves as far as food, shelter, safety, and so forth. In fact, the language that you are required to show is for both conservator and guardian is the specific physical or mental conditions which prevent the incapacitated person from being able to receive and evaluate information or to communicate decisions to such an extent that he or she lacks the capacity to meet essential requirements for food, clothing, shelter, safety, or other care such that serious physical injury, illness, or disease is likely to occur. So you must show that the person has a level of disability or incapacitation such that they cannot take care of the normal things, daily activities and so forth, without risk to themselves. That's essentially what that requirement is, and that's the specific language that you have to show. Now, normally, to show the physical, that the level of incapacitation, either physical or mental, is such that you need a doctor or a physician to submit a diagnosis, and the result of the diagnosis to the court. And typically that's done in the form of an affidavit, which is signed by the physician who has, this would be the treating physician or the diagnosing physician, that is normally required to be submitted as evidence to show the level that the person has a sufficient level of incapacity such that a guardian or a conservator is needed. Again, we invite your questions or comments. Just go to our Facebook page, facebook.com/Raymond Law Live. So we'll entertain any questions or comments that you may have. So those are some of the basic considerations for whether or not you want or it's desirable or advisable to seek to be appointed as a conservator or guardian of an incapacitated person. This is a rather involved process, and it requires, again, evidence from a treating or diagnosing physician as to the level of incapacitation, either mental or physical. It's got to be sufficient that the person needs a guardian or a conservator. And once you go through the requirements that are set forth in the petition, and you're appointed, then you continue under the supervision of the probate division. You have to get court authorization, for instance, to make certain expenditures of the incapacitated person's money and finances, and you have to report to the court about the person's condition on an annual basis. There's several different kinds of requirements that that come with being appointed as a guardian or a conservator, and it is a big responsibility, and that should be considered as well, because it's a lot to do. But if that becomes necessary, then, and in some instances it does, then you need to consider it carefully, and you may want to first consult with the healthcare provider, either your loved one's physician, a treating physician, primary care physician, about that person's condition, to see if the level of incapacitation is such that seeking a appointment as a guardian or conservator is warranted. And again, you will need to seek counsel to assist you with the whole process of seeking an appointment to be a guardian or a conservator that is needed. So you need to consult with an attorney, and you need an attorney to assist you with handling that process, which is fairly involved. And I've discovered in my practice that the requirements can be they're pretty strict, and not everyone can qualify to be a guardian or a conservator. So that wraps up our discussion of today's topic. If I don't have any questions, let me again thank you all who are watching this broadcast live. And I want to thank those who will be watching the broadcast later for tuning in. We appreciate your interaction, and we appreciate your tuning in. Remember, if you want to contact us, you can contact us at Raymond Law Live, Facebook.com Raymond Law Live, or Twitter at Raymond Law Live, or you can call our office at area code 314-534-2800, or you can go to our website, that's RaymondLawLive.com. So thank you again for watching, and remember, when you fight, know your rights. We will see you. Tune in for our next broadcast on Tuesday, April 23rd at the same time, 6 p.m. Central.